morning, and I'd like to begin by thanking everybody for attending this important oversight hearing on California workers' compensation system. Today we are gathered to discuss an incredibly significant matter for the workers of Los Angeles County and the surrounding region. However, as we gather in the Downey City Hall, I would like to begin by paying tribute to one of the city's heroes. Downey police officer Ricky Galvez lived a life of service and dedication to our community, our state, and our country. He was the officer that was killed last week, I believe, here in the parking lot right outside. So he was done with his shift here, and his funeral was just this past Monday. And just want to take a moment to acknowledge that and just give my respects. He is an example of the finest quality of citizen our nation can produce. He will be sorely missed. Just want to take a moment just to recognize him and his memory, and just pay my respect to his family and the city of Downey for their loss. Today we are going to hear from a wide array of stakeholders who will speak on the state of workers' compensation in the greater Los Angeles region, how local dynamics have statewide implications. This testimony will cover recent research on how the greater Los Angeles area differs from the rest of California, how the workers' compensation system shapes local governance, and how local dynamics impact stakeholders throughout the workers' compensation system. Noting the important role of the Los Angeles region in shaping the economy and culture of California, I look forward to working with everyone here to ensure that the grand compromise that is California's workers' compensation system continues to meet the needs of California's injured workers and employers. I would like to start bringing the first panel forward. Our first panel speaker is Desti Overpeck, Administrative Director of the Division of Workers' Compensation System. Thank you so much for being here, and I appreciate your time, your indulgence, and your information.
Good morning, Senator Mendoza. Thank you for having me here today. In order to have some background on the discussion about Los Angeles area versus the rest of California, I'd like to start by providing a little bit of information about the entire system. Specifically, I'd like to address how Senate Bill 863, which became effective on January 1st, 2013, has improved the system and addressed some of the state regional differences. First, SB 863 addressed some major problems in the system. Permanent disability benefits had been cut by more than 50% as a result of SB 899, which was from 2004. The delivery of medical treatment had issues in which employees were complaining of delays and denials of care. Employers were complaining about runaway costs and the inability to block unnecessary medical treatment. We had delays in dispute resolution, primarily because of the numbers of liens that had been filed and were choking the system, especially in Southern California. And costs in California for workers' compensation still remained the highest in the nation. SB 863, which was a bipartisan bill and was negotiated by labor and management, has improved the system. It increased injured workers' permanent disability benefits. The increases were approximately 30% in 2 steps. The first increase was for both the minimum and maximum permanent disability payments, which occurred on January 1st, 2013, and then there were further increases on January 1st, 2014. In addition, all of the impairment ratings are now modified by a 1.4 modifier, which is larger than before. It was a range of 1.1 to 1.4. There's also improved injured worker access to medical care, In workers' compensation, medical treatment must be evidence-based, and that happens by following the medical treatment utilization schedule. The purpose of having evidence-based medicine is to prevent both harmful overtreatment or undertreatment for injured workers. The improved medical care includes changing the previous system in which a qualified medical examiner would help resolve treatment disputes, which would then go to a judge, to having the independent medical review system. In workers' compensation, if a physician recommends treatment for an injured worker, the physician provides that request on what's called a request for authorization, and it gets sent to the claims administrator. If the treatment requested is not evidence-based, then a utilization review physician can review that request and make a determination of whether to grant or deny the treatment request. If it's denied under the independent medical review system, the injured worker may apply for an independent medical review. This is before an independent physician reviewer. And now, the entire process takes approximately 45 days, whereas previously it could take 6 months to 9 months to have that same dispute resolved. There were also changes to the medical provider networks. There are now medical access assistants who are available to help injured workers locating appropriate doctors and getting appointments. There's better monitoring of the medical provider networks through the Division of Workers' Compensation, which can do investigations and reviews. We can invoke penalties if the MPN is not following the regulations. The physician rosters are required to be up to date, and disputes about medical provider network issues are now resolved as an expedited hearing, which means it gets resolved within 30 days. We also have increased system efficiency, partially because of the electronic filing of liens, which is one of the requirements under SB 863, and because of the requirement that liens must pay a fee when they're being filed, which has substantially reduced liens being filed in the system. There is also a new method for resolving provider bills, and this is called the independent bill review. Instead of having to file a lien, which is again a very lengthy process and expensive, if there is a dispute about a provider bill, the provider can ask for a second review, and then if there's still a dispute, they go to the independent bill review process. Once that request has been assigned to a reviewer, the request is handled within 60 days. You have to have either a contract agreement or a fee schedule in order to use the IBR process, and so we have also revised and updated all of the fee schedules. We previously had Medicare-based fee schedules for most of our medical providers. After SB 863, we updated the ambulatory surgery center fee schedule and the inpatient hospital fee schedule. As of January 1st, 2014, we had a new physician fee schedule. On July 1st, 2015, we implemented a copy service fee schedule. We just had a public hearing for a home health fee schedule yesterday, and the interpreter fee schedule is the next one that will be coming out for public notice for the regulations. SB 863 also changed the supplemental job displacement benefit program. It is a $6,000 voucher to help injured workers find new jobs if there's been no return to work offer. And we now have a return to work fund, which is an additional $5,000 benefit for injured workers who do receive that voucher. So the next group of slides shows how the Los Angeles area district offices compare to other parts of the state. This slide shows the opening documents for the 24 district offices. The blue line are the LA Basin offices. We have included in that description Anaheim, Los Angeles, Marina del Rey, Santa Ana, and Van Nuys. LA Basin handles more than 50% of the cases than in Northern California. This is a similar concept. This is broken down by region. We have the statewide total, which is the top line. And then southern is the green line, northern and central. Again, you can see how many more cases are being heard down here in Los Angeles. This slide illustrates that the Division of Workers' Compensation has almost 2/3 more workers' compensation judges in Southern California than, for example, Northern California to handle the busier offices. The next slide is a breakdown of our workers' compensation judges per district office. Again, we have more resources for the offices that are the busiest offices. And as you can see, Van Nuys is our busiest office in Southern California. This slide illustrates the number of expedited hearings. We have more expedited hearings available now to injured workers. SB 863 amended Labor Code Section 5502, which discusses what bases you can go in for an expedited hearing, and it added the right for whether an injured worker is required to treat within the medical provider network, issues over medical treatment appointments and medical legal exams. So as you can see, every year since 2012, we have been able to provide more expedited hearings, which of course are the hearings within 30 days, and specifically greater in Southern California. We have also made efforts to achieve uniformity and to equalize the workloads. For example, we recently promulgated uniform forms for the pretrial conference statement and the minutes of hearing forms. We train our judges on procedures. We want it to be partially, the Labor Code requires it, but we also want the district offices to be as similar as possible in their procedures. We have created a lien conference calendar, so all liens go to that calendar, which keeps them separate from the injured workers' disputes. We have made it so that less busy district offices can assist the busier offices. And so, for example, we've assigned lien cases to other offices. We're using video trials. For example, what we're currently doing is in Anaheim, the parties can appear and the court reporter will be there. And then using software similar to Skype, the judges in Eureka or San Luis Obispo can actually hear the lien conferences or the lien trials. We also are using court call, which is of most assistance, I would think, in areas like Los Angeles, where there's a lot of traffic, to save the parties from having to, or at least the attorneys, from having to drive to the various district offices.
I have a question. How do you decide when to conduct a video trial or a court call? How does that come up? Who decides that?
I do not know the answer to that question, but I can find out and let you know.
That'd be great.
Okay.
Yeah, just wondering how that works. But I wish we could do that instead of me flying to Sacramento every week. It would be kind of nice just go ahead and plug in and do it from here. But I appreciate that. Thank you.
Okay. I do know we're currently doing it more as a pilot program, but I think that the intention is to make it mandatory, and it will give us more control over the calendars. So I'm going to talk a little bit about liens now, because liens were one of the most dramatic changes, in my opinion, that we had resulting from SB 863. As you probably know, lien filings were especially high in the Los Angeles area, and that takes away resources from injured workers. If you look at this chart, starting with 2011, that is the blue line. That, of course, is before we had lien filings. And by December of 2011, we were up to almost 50,000 lien filings per month. And then starting in 2012, it was even above 50,000. Of course, it peaks because everybody knew that SB 863 had been signed and they were going to have to file a lien filing fee. So, I mean, the end doesn't really count as normal. But if you look at the years below the 2011 line, you can see we've had a substantial decrease. Initially, it was about 60%. It's gone up a little bit this year. We think it's because there is a statute of limitations that is now coming to fruition, and people want to get their liens on before that statute of limitation time gets cut off. There was a recent case called Angelotti in which the lien activation filing fees were challenged as unconstitutional. The court ruled that they are constitutional, so we were stopped from collecting activation fees for a while. We have started again. As of the end of this year, all old liens must have filed the activation fee, or they will be dismissed, which means as of January 1st, for the first time, we will know exactly how many liens we have filed in the workers' compensation system. Additionally, as I mentioned in the beginning, liens must be filed electronically, which means that we have more efficiency in our offices because we have less people handling all that paper filing. Okay. This shows lien conferences by region. Again, if you look at the green area, you can see that, well, blue is 2012, and you can see the lien conferences have been going down and down and down. So that is reflective of the fact that we're having less liens getting filed in the system. All right, independent medical review. So independent medical review was designed to provide quicker medical decisions that would be evidence-based using the medical treatment utilization schedule. And the decisions would be made by physician reviewers as opposed to our workers' compensation judges. This was also recently challenged as unconstitutional, but the Stevens case has held that the IMR program is constitutional. So in this slide, so you know FDL stands for Final Determination Letter, and the blue bar shows how many unique applications for an independent medical review request come in per month, and the green line shows how quickly the decisions are issued once the application has been assigned to a physician reviewer. The time difference is there is a 15-day time period for records to be sent in. But as you can see, we're now, under the statute, there's 30 days is allowed to get that medical decision out. They're now coming out as low as 10 days after they've been assigned. So we have now gotten to the place where these medical decisions are coming out in a very speedy manner.
I have a question. During the independent medical review, is this where, I know they brought the concerns to me in the past, where is this where the person that's reviewing it actually reviews the paperwork but never actually examines or looks at the patient?
That is correct.
Is there a reason for that? I'm not...
Yes. Similar to group health, when there's an appeal of what the treating physician recommendation is, The doctor's records and the doctor's request is reviewed on paper by a physician reviewer. So it was modeled after the Knox-King Act, and it's similar to how the utilization review process also works throughout the country.
Do you think it would make a difference if they actually got to examine the patient and just the paper instead of just the paperwork, or it wouldn't make a difference? What do you think?
Well, the process we had before with the QME process did involve having an actual physician review or examine the injured worker, but in order to do that, you give up getting quick responses to a medical dispute. The experts tell me that you can appropriately make a decision based on what you're given in those medical records and in the, doctor's evaluation.
So the medical community feels they could do it on paper only? That's what I'm hearing?
Yes.
Okay.
Okay. All right, so this is getting into the breakdown, again, of the Los Angeles area versus the rest of the state. And I know that there's been questions about are there a lot more IMR decisions that are coming out of Los Angeles? So the red line shows, based on our data in our workers' compensation information system, how many claims there are for each of these regions, and then the percentage of claims for each region. And then the blue line is the percentage of IMR cases. So as you can see in LA, there are, ratio-wise, more IMRs coming out compared to the WCIS claims, compared to, let's say, the Bay Area, where it's the reverse. But I do want to point out that LA is not the only area where you see that. It also is a higher IMR versus claims number in the Inland Empire, in the Central Valley, in the Central Coast, Eastern Sierra foothills. This chart gives this, so an independent medical request can have more than one treatment request within it. For example, the physician can say, you need an IMR, and you need to have this prescription, and you should also, have some physical therapy. So this is a breakdown of how many treatment requests on average by region. Again, Los Angeles is at the top of our chart with approximately 2 treatment requests per IMR. But again, that's compared to San Diego at the lowest number of 1.73 or the statewide average of 1.9. It's not a huge difference here that we're talking about. And finally, this chart shows the top treatment requests that we have in IMR. By the way, you'll note pharmaceuticals is the highest type of treatment request dispute that we have. And as I'm sure you're aware, we recently had AB 1124 that will require us to have a formulary for workers' compensation, and we are hopeful that the formulary will help address the high number of pharmaceutical disputes that we get in workers' compensation by clarifying which medications should easily be approved if they've been requested. What I find interesting in this slide is proportionally, Los Angeles is right along the average of the state average. The state average is the purple line, and Los Angeles is the blue line. As you can see, for pharmaceuticals, the state average is 41%, and same as Los Angeles, which is 41%. And it kind of is the same going across the board. If you look, again, this is proportionally, but by the type of treatment request. So in conclusion, I'd just like to say that SB 863 has provided us some tools to improve the system with increased benefits, new procedures for timely, evidence-based medical decisions, expedited hearings for medical and benefit issues, and better procedures for fee disputes. The changes to the lien processes allow greater access for injured workers to our district offices, and the changes made by the Division of Workers' Compensation have allowed for a better balance of the district court's workloads. Thank you.
Thank you so much for your presentation. Go ahead and bring our next speaker. It'll be Rena David, Senior Vice President of the California Workers' Compensation Institute.
Yeah, actually, we're going to switch.
Got it. So we're actually going to be Mark Priven,
Right.
Director of the Data Analytics and Specialty Actuarial, Brickmore.
Okay, great. Thank you, Senator. Good morning, and thanks for the opportunity to speak here today. I'm just going to give a pretty high-level overview of differences between Los Angeles and the rest of the state in workers' compensation, and then following me, Rena David will drill down into some more details regarding that. So I'm going to talk about 4 different issues. The first one is loss rates, which is basically the cost per $100 of payroll. So this is what's this is the basis for what employers pay, whether they're self-insured or whether they buy insurance. It's the loss rates per $100 of payroll, which really drives how much they pay. I'll cut to the chase. It's much higher. The loss rates are much higher in Los Angeles than they are in the rest of the state. That's true whether you're insured. It's true whether you're self-insured public entity. It's true pretty much across the board. There's 2 potential reasons why loss rates might be higher. One is you have more claims, or the second explanation is those claims that you have are more expensive, right? In Los Angeles, it's both. So Los Angeles tends to have more claims, higher claim frequency per $100 of payroll, and those claims that occur in Los Angeles tend to cost more. So it's both aspects are driving the claim costs in Los Angeles region to be higher. And then the last thing I'll talk about is claims administration environment. And basically what I'm going to show, based on some claim audit data from the Division of Workers' Comp, is that basically it's harder to administer claims in the Los Angeles region, that the claims administrators almost across the board don't perform as well in Los Angeles as they do in other areas. So I'll get to that. Okay, so first of all, loss rates. So this slide shows in the insurance world what an employer or what insurance companies charge in the Los Angeles region versus the rest of the state. So these percentages represent essentially a surcharge for an employer that is paying insurance in the state. And this is just a sampling of 6 insurers. Insurance company filings are public information, so I just went in, grabbed some filings, and looked at how much they surcharge for the Los Angeles region. So depending on which insurer an employer is going with, that employer is going to be surcharged anywhere from 11 to 32% compared to the average employer in the rest of the state. Just to show that this isn't a generic Southern California issue, I compare here Los Angeles versus San Diego. And what you can see here is that while the Los Angeles region in blue is getting a surcharge, those employers in the San Diego region are getting essentially a credit off of what a statewide rate would be for being in the San Diego area. So it's sort of the insurance world is weighed in that the Los Angeles region costs more, the San Diego is less expensive. So that's the insurance company world. I also looked at self-insurers. So these are public entities, primarily schools, counties, cities, and some special districts, and compared their loss rates, controlling for mix. And what this shows is that on average, in Northern California, there's a 22%, call it credit, or paying less than average. Whereas in Southern California, it's about 14% higher. And I wasn't able to do this for Los Angeles specifically, so sort of all Southern California is lumped together. But in a sense, it's consistent with what the insurance companies are seeing in that Southern California costs more.
For these government entities who actually have their own self-insured, it still probably seems like a lot cheaper than if you were to go with a private insurance. If they were to hire, would it be like, I think insured, like 32% potentially?
The insurance world was, I think, somewhere between 11 and 32%.
Okay.
But you're right.
Yeah.
But the other thing is, so that slide showed Los Angeles specifically. This is
Right.
all of Southern California. So this is
California.
kind of a blend of LA and San Diego and other areas that might not be as expensive as LA. So now breaking down the loss rates into the two components, claim frequency and average claim size. This is again, we're going back to the insurance world, and we're looking specifically at claim frequency. Sort of the red regions are the ones that have higher claim frequency, and the blue regions are the ones that have lower claim frequency. And you can see sort of there, the darker red area, the Los Angeles area, has a claim frequency about 30% higher than the statewide average. And Northern California, the Bay Area, has about 15% lower than average. So this particular slide, this comes from a relatively recent study put out by the WCIRB. This is specific to indemnity claims, which are the ones that tend to cost more and drive the system. There's a similar graph for all claims, and it shows but pretty similar results. So again, in the insurance world, what the insurance world is seeing is that the LA region has much higher claim frequency than average. And this shows sort of some changes over time. So this is an index of claim frequency. And so everything is tied to the 2004, where the index starts at 1.0. And then the lines are going to go up or down depending on whether the frequency goes up or down in that given year. And what I conclude from this graph is that from 2004 to 2007, all the regions behaved very similarly in terms of how the frequency went down. But then somehow, starting in 2007, the green line, which represents the Los Angeles area, started to see a frequency increase, whereas the rest of the state either saw sort of no increase at all, which is the other regions, the dotted red line, or actually a frequency decrease, which is the Bay Area. So starting in 2007, really the experience of Los Angeles sort of diverged from the rest of the state. The other thing I'll just add is the sort of the purple line there with the small little dots. That's NCCI, which is basically a nationwide average. Okay, so just as a benchmark against what's happening nationwide, the Bay Area since 2007 has actually outperformed in terms of seeing more of a frequency decrease than nationwide. Other regions are pretty close. And Los Angeles sort of by itself is seeing a frequency increase. Okay, so something happened starting in 2007. The prior slides I showed were about frequency in the insurance world. This talks about claim frequency for self-insured public entities. And again, here we see Northern California is about 10% lower than average, whereas Southern California is about 5% higher. And the central has a big increase. I think that's just because there's not a lot of data in there. But sort of the central message is that even similar to the insurance world, self-insured public entities are seeing a higher frequency in Southern California than Northern California. And now switching to the average claim size, same thing. So Northern California is seeing smaller than average claim sizes, and Southern California is seeing larger than average. So as I mentioned before, the LA region and Southern California has both more claims, and those claims that it has tend to cost more. So this shows that those claims that they have tend to cost more. This is the self-insured world, and it's true in the insurance world too, and part of what I wanted to show here is the distribution by claim type. So really the rightmost, what's encircled there is the most important area, because The permanent disability claims are the ones that really drive the cost in the system. As I mentioned there, over 85% of costs come from just those small percentage of claims. Those are the most severe injuries with the highest cost. And what this shows is that of those claims that do occur in the Bay Area, only 10% are permanent disability, whereas in the Los Angeles area, it's 14%. So that 4% may not seem like a big difference, but when you go from 10 to 14, that's actually a 40% jump, right? And if these are the most expensive claims, that can be a big part of the explanation of why claims in Los Angeles area tend to cost more. They tend to be more likely to have permanent disability. The last thing I want to talk about is claims handling performance. This is based on Division of Workers' Comp performance audit reviews, we call them PAR reviews, and it looks at things like timeliness of temporary disability payments, timeliness of permanent disability payments, things like that. And what this shows, it's kind of like golf. The lower the score, the better, okay? And so on the left-hand side, what this shows is that in the blue bar, the California x Los Angeles score, 1.09 is much better, much lower than what those adjusters have in the LA region or those even outside California. So what this implies is that those adjusters in the LA region tend to have a harder time making timely payments, temporary disability payments, permanent disability payments, all that kind of stuff. The next slide is similar, but it breaks it down by type of administrator. So what this shows is that consistently for insurers, for third-party claims administrators, which may work with an insurer or may work with a self-insurer, and even on the right for those entities that self-insure and even self-administer their own claims, so they don't have a third-party claims administrator, they handle the claims themselves. For all of those different types of administrators, the blue bar is higher than the red bar, which means that the Los Angeles area audits came out with a inferior score to the rest of the state. So it's very consistent. It's not just an insurance thing. It's not just a self-insurance thing. It's very consistent across all. So in summary, again, the high-level overview, the loss rates are higher in LA. That's more claims per $100 of payroll, higher claim frequency. For those claims that occur, they tend to cost more, and that the claims administration environment is more difficult in LA.
Wow.
And I think that's it. Any questions?
Great, thank you so much. Yeah, well, some of the other panels will be answering the more difficult questions, but thank you for the information. Really, really well presented. Thank you.
Thanks. Sure.
Now I would like to bring up Rena David, Senior Vice President of the California Workers' Compensation Institute. Thank you, Rena.
Good morning, Senator.
Good morning, Rena.
Let's see, I'll wait for the deck to come up. For today's discussion, I'm going to be drilling down on some of the items that Mark talked about, focusing on differences between Los Angeles, the LA Basin, and the rest of the state in terms of the characteristics of the claim, and then get into some of the cost differences and some of the drivers for the medical costs. And lastly, I'll be going through some additional IMR statistics for 2015. So the first item I'm going to be discussing is the days it takes from the date of injury to employer notification. And this is important because the longer this takes, the harder it is to facilitate the care for the injured worker. And on the left, you'll see a map that shows the number of days by county, with the green being the lower days and the red being the higher days. Overall, in the LA Basin, the average was 21 days between the date of injury and the employer notification, and it's more than twice as high as it is in the rest of the state. If you look at the next number, the median is only 1 day, which means that at least more than 50% of the injured workers notified their employer on the same day of injury. The difference between that median and the average means that a smaller number of cases are driving that higher average. Then once the employer is notified, how long does it take to get the first treatment? And here again, the average is higher, about 30% in Los Angeles, but the median day, or even up to 75% of the injured workers actually get their care on the same day or prior, even prior to when the employer is notified. Again, the outliers seem to be driving that higher average in Los Angeles. I'll be moving from, the other statistics were related to all claims in the system. I'm going to be moving to talking about the lost time claims, permanent disability or temporary disability. And you can see from this chart that Los Angeles claims stay open longer. So 77% closure rate versus 82% closure rate for the claims in the last 10 years. Probably the most significant difference we found between LA and the rest of the state was in the rate of attorney involvement. The LA Basin had 58% of their lost time claims with an attorney involved, meaning either an applicant or a defense attorney. And as we'll see later on in the presentation, this can have a large association with differences in costs. So getting into those cost differences, if we look at this first slide, that first set of bars represents the difference in total costs between Los Angeles and the rest of the state on a paid basis. And by the way, my definition of LA Basin in this is Los Angeles County, Orange County, and then the Inland Empire. So I think we all have slightly different definitions, but that's what this represents. When I took the same data and split it into attorney-involved claims versus not, you see that the differences drop down to quite a bit, only 5% difference overall, and 10% higher. Actually, I'm going to go back, and I think I'm going to go back on the prior slide. You can see that of the differences, the medical expenses were 40% higher, the indemnity cases were 18% higher, and then the expenses were almost twice as much. So that's how it breaks down by type. Sorry, now I'm going to go to the next slide, which shows it when an attorney is involved. Again, the overall cost, paid amount per claim is only 5% different. Medical is 10% higher, and indemnity expenses are actually lower on a per claim basis, with expenses being higher as well. When I look at claims where an attorney wasn't involved, there's no difference overall. The next area we looked into was we wanted to dive into what were some of the drivers of that differences in medical costs that we were seeing. And through statistical modeling, we identified the top drivers for cost, the most impactful characteristics of a claim that's going to make it cost more. And what we found in this model is that if we take all of these characteristics into account, we wouldn't see any difference with Los Angeles. So this model pretty much explains the difference. And I'm just going to go through each characteristic. The employee and job characteristics, that's what industry the employee was in, what their age and gender was, how long they've been in the job. The combination of those factors would predict a slight increase in the cost per claim. Likewise, the higher rate of attorney involvement and the fact that as Mark mentioned, there is a higher proportion of claims that are permanent disability. Both permanent disability and attorney involvement are high predictors of costs, everything else being equal. injury characteristics, interestingly enough, this is where we looked at the mix of nature of injury, cause of injury, and body part, and said, all right, all things being equal for the other characteristics, we would have expected the cost of the claims to be lower in Los Angeles rather than higher. Again, all the other factors being equal. Another thing we looked at is the actual medical diagnoses on the claim. Mental health came out as a high predictor of costs, but there were other diagnoses also that could either drive up or down the costs. Overall in Los Angeles, these were higher. And then lastly, treatment differences. We found that just the presence of one opioid on a claim is a tremendous predictor of higher costs. That factor is actually lower in the Los Angeles area overall. And, but the psychotropic drug use, it's drugs traditionally used in mental health, but also is used for pain management. That's higher. And then inpatient stays, when you balance Inland Empire and LA, is about neutral. So what I did in this pie chart was kind of take all of those factors, and I took a look at the different components that were driving the change and weighted it for both how often it occurs and how impactful it is, and identified these as the proportion of what cost drivers are driving the higher cost. And what we found is, if you look at the little orange bar there, the employee job, that the differences in industry and age and all of that contribute about 13% to the higher costs in LA. Attorney involvement and permanent disability together explain about half the cost difference. As we move along, you can see this comorbidity, mental health. This was one that was a surprise to us. It really came out as a much higher frequency, much higher likelihood that a claim in the Los Angeles area would have a mental health diagnosis associated with it. This isn't the primary diagnosis, but a secondary diagnosis of mental health. And that contributed to about 25% of the cost difference in our model. So that was a surprise. And then additional diagnoses, again, contributed another 15%. So we feel like in this model we've identified that there are a number of factors that are reasons why LA is different, and these came out as the high ones. We also there was a concern that, well, if we compare LA to the rest of the state, they're different urban areas, may not be exactly comparable. So we did the same modeling for Los Angeles versus San Diego and Los Angeles versus Bay Area, both of which have much lower predicted costs, and found fairly similar results. A little bit differences here and there, but pretty similar. So the next section I was going to talk about was just give, the administrative director already gave an update on IMR. We just released the report this morning that dives into detail on the 2015 results specifically, so I'm just going to share a few of those results here this morning. First, to set the context for the independent medical review program, only care that is denied or modified through the UR process needs to be reviewed in the independent medical review. Everything else is paid or approved. And what we found in our study is that about 4% of the total care provided ends up being denied or modified through the UR process. So it's that 4% of care that's eligible for IMR. Now, so this is a breakout of 2015 IMRs by county. You can see this is just by volume. And these are the individual decisions, not the letters. And as Desi mentioned, there are more decisions per letter in the LA area. So there are pockets throughout the state of the higher volume. What we found overall for Los Angeles, that there was 34% of the decisions came from the Los Angeles County area, and in our data for the mostly insured with some self-insured employers, we found that 23% of the claims, so that we had a ratio of about 50% more claims than expected based on the claims numbers. But what we found for LA, and fairly similar to the statewide average, is that 91% of the time when the reviewer did the review, they validated the UR decision. And so they overturned the decision in about 9% of the cases. We also looked at the concentration of the reviews and probably related to the denials in individual providers. And what we found is that the top 1% of the providers named on the letters drove 40% of the decisions, and the top 10% drove 81%. So it's very concentrated in a small number of providers. We found that same pattern in the LA basin. The one difference we did find in LA is the top 10 individual physicians in Los Angeles were responsible for 18% of the volume. And that same number statewide was more like 12%. So just the 10 individual doctors.
So that's a powerful statement. That's a powerful statistic, I guess. There's only 10 individual doctors. Who are the 10 individual doctors, and why do you think they would drive 18% of the cost?
Did you say, we are not, under our agreements with the data collection, we're not allowed to identify those, but I believe the division, that's something that could be asked of the division.
Okay.
Similar to what Desi reported on, pharmacy is definitely the highest treatment category. We found in our data for 2015 that the Los Angeles and Inland Empire areas had a somewhat lower proportion of pharmacy, and that was made up by DME and physical therapy. So in summary, what we found in our data analysis is that the Los Angeles basin had generally higher claim costs, higher, and I have PD rates, and I get that's confusing, higher proportion of claims with permanent disability, higher attorney involvement rates, higher diagnosis of mental health disorders, and somewhat delayed claim notification on average, again, not for the typical, but definitely on average, and then higher expenses to manage the claim and IMR costs.
Great, thank you. Great presentation. I appreciate you providing all those facts and great charts, and it's a lot of information, but it's very informative. Thank you so much. Okay, that concludes our first panel. They pretty much spoke about the impact of LA on California's workers' compensation market. Our next panel is going to be talking about pretty much the public perspectives, workers' compensation as it relates to workers' compensation in LA County. For that, we'll be bringing up Steve Robles, who's the Assistant Chief Executive Officer for Los Angeles County, to make a presentation. Thank you, Steve.
Good morning. My name is Steve Robles. I'm the Assistant Chief Executive Officer with Los Angeles County. I want to thank you for the opportunity to speak to this particular topic. I oversee the entire risk management branch. We are located within the CEO's office of LA County. We, as part of the risk management branch, oversee workers' compensation, liability, disability management. We also oversee loss control, occupational health programs, as well as employee assistance programs. We are self-insured. To administer our workers' comp claims, we currently employ 4 third-party administrators who help us oversee that administration. The County of Los Angeles employs approximately 100,000 workers that perform a variety of public entity tasks. Our workers' comp program is the largest local agency program in the state of California. We have approximately 27,500 open workers' comp claims, and we get about 10,500 new claims per year. With that, our injury frequency rate is approximately 10.5%. We've seen an experience over the last 4 years with that rate to be relatively flat. We haven't seen increase or decrease within a certain percentage amount. We have seen a developed litigation rate of 24%, which is down slightly from 28% that we experienced in the early 2000s. In fiscal year 14-15, our total costs were approximately $427.7 million. Our allocated and unallocated loss expenses account for approximately 21% of our total costs, and that is about $90 million. And as you can see on the slide, we have a 51% increase in those costs from fiscal year 2003, 2004. We have very, very complex and specific program, and so we've brought along today Mr. Alex Rossi, who has been working on this program for several years. I want to say decades. I don't know if it's decades, but it's very, very long time. I'm going to have him get into the various details of our program. Mr. Rossi.
Thank you, Steve. Honorable Senator Mendoza, committee members, thank you for allowing me to speak today. As Steve mentioned, the County of Los Angeles has 100,000 employees, and those occupations range from eligibility workers to physicians, nurses, firefighters, sheriffs. It is the program's responsibility to care for those dedicated employees. So I think that's the primary obligation of every workers' compensation program, whether it's an insured program or not. And clearly that's our initial obligation. At the same time, every dollar we spend on this program, scarce tax dollars. So we have to administer the program in a fiscally responsible manner. What this slide shows is a breakdown of the major benefits that we pay on the program. It does not include salary continuation or Labor Code 4850 benefits, but you can see kind of what our goal was stabilization. And during the course of this, I'm going to show you, use fiscal year 03-04, because that was a year prior to the influence of SB 899. SB 899 had a significant impact on the workers' compensation environment. It had a significant impact on the county program. And what you can see in the medical is we've been relatively consistent. We actually went down significantly from $157.8 million to the current fiscal year of $144.7 million. And that's actual paid out dollars. That's what we actually pay out every year on all claims on the program. Our temporary disability benefits have decreased slightly. Our permanent disability benefits are showing a significant increase, and this year they're increasing more. And I believe the reason that is happening is because the old $140 rate is being supplanted with the $230 or the $290 rate. And really, this was the intent of SB 863. In part, these increases are kind of predetermined so we could plan for them. And this demonstrates, and I'd like to point out on our frequency, even though it's 10.5%, which is very high, it's driven by our sworn departments. Our fire department's around 28%, sheriff is around 23, 24, probation 13. When you pull those out, the overall county frequency rate for injuries is around 6%. Here we're showing how much money we've paid without salary continuation in 4850, again using the baseline of 03-04. And overall, countywide, it's up 10.77% over those 11 years. It's actually down when you pull out safety. We actually went down, we're at 1.88% comparative when you pull out the safety departments. And we've defined the safety departments as sheriff, probation, and fire. What this slide demonstrates is a comparison of the Office of Self-Insurance Plans, public entities, what they report as their payouts on medical, and the counties. And as you can see here, again, there is a dip prior to the implementation of evidence-based medicine. The cost to the county was $157.6 million. We saw a significant drop as soon as we saw the implementation of utilization review. There's been stabilization over 10 years. Our experience has been an increase of 33.9%, and statewide, the increase is at 41.8% over 10 years. And these are just public self-insured, and what their actual payouts are per year. This is reflective of information that was provided in the Commission on Health, Safety, and Workers' Compensation annual report that showed the inflationary pattern of workers' compensation prior to 2004. The county was seeing escalations in program costs anywhere between 10 to 20%, which we believe was not sustainable, okay, per year. These are per year. And this was reflected in the overall inflationary cost in workers' compensation. You can see that dip, and that dip was reflected in the prior slide. So now you see a decrease in the inflationary rates. And this is a projection. So what we did here was we took a look at fiscal year 03-04, and we used a conservative 11% increase if there was no legislation that would have addressed the workers' compensation crisis, because that's what SB 899 did. And this slide reflects that the county workers' compensation costs, excluding 4850 and salary continuation, would be over $1 billion in fiscal year 14-15. It's currently, it was 359.347 million. One of the issues I think that we face as a workers' compensation program is trying to balance the provision of adequate benefits and fiscal sustainability. I've been doing workers' compensation probably 30 years. I have never had this conversation with an injured worker, and I've spoken to about 1,000 injured workers. You're paying me too much money, and you're providing too much medical care. I have never had that conversation. I also have never had the conversation with an executive or manager who was looking at their workers' compensation budget who said, oh, we're paying too little, we should pay more. So it's this incredible balancing act, and I really do highly appreciate the ability to come in here and discuss it a little, and the county's experience. So what we're looking, I think what most people in is what I can expect. I know when I go see a physician, I'm going to get quick medical care. The medical treatment will be evidence-based. And I think employers want that as well, at least the county does. What we've looked at in utilization review, we've had to have discussions with actual physicians that we trust. And when we look at utilization review, we said, what are the problems you're having? So they said, well, we're having problems getting physical therapy authorized. So we set our utilization review triggers for physical therapy at 24, which means a claims examiner has the ability to authorize up to 24 visits. Post-surgery, they have up to 36 visits. And with medical MRIs, we wanted the immediate ability to have MRIs. If a doctor requires an MRI, we want to give them the ability to order the MRI and have it approved. So I think it's open lines of communication with physicians is very, very important. On our program, I think we've had some good success with that. One of the things that Rena addressed was comorbidities. And this is something that is very difficult to influence. The CWCI did have a study when obesity was a comorbidity. The cost of the claim, of an indemnity claim, increased 80%. That is really out of the control of most employers, even though we have a wellness program. Department of Human Resources developed a wellness program. That's wonderful. The other thing I'd like to touch upon here is profiteering. And I don't know, because I only administer cases, I only deal with Southern California, LA Basin cases, whether there's more profiteering going on in the LA, Long Beach region than there is in Northern California. But as many of you probably read, the U.S. Department of Justice just had a press release that came out on Operation Spinal Take pills and compound medications or alternative But on our program, when we took a look at compound utilization, we had a pharmacist take a look at it, and they pointed out that, look, it's a high level of compound medications, too high, and it was several physicians driving that cost. And we were able to utilize the utilization review process to address focus on compound medications, and many of the compound medications were denied because of that. The other area, physician-dispensed medications, that is one area. What we've noticed lately, and this is something that just kind of came up, was Synvisc 1, which is a solution that is injected into someone's knee. And the physicians are using it, and I've heard have wonderful results with it. The pharmacies that are providing it, some of the pharmacies are billing it at 48 milligrams. The fee schedule indicates you have to, because it's a solution, have to bill it at milliliters. But when they're billing it, they use the 48 units, and they're charging $10,000, $12,000. And if the bill review company doesn't catch it, they're being reimbursed $9,000 for something that only should cost $1,000. So it is a concern, and it's something that we have to watch, and it's something that's going on right now. The other thing is, and I'm not a pharmacist, but this is very interesting, because we're talking about being able to predict costs in a system. And so we had a case where someone was being prescribed dibenzoline, and it was $10.07 a pill, 10 milligram pill. On October 3rd, 2014, the cost suddenly spiraled to $87.20 per pill. So very quickly, it went from $10 to $87. Currently, it's, and I believe, and this is the lowest NDC rate, it's currently $236. Now, in this particular case, we spoke to the physician, and the physician said, I can't believe that's happening. We're going to wean the individual off of this and have her on another alpha blocker that is safe. So the physician didn't even understand this was going on. And so these are some of the pressures and some of the needs for managed care that we're seeing on the work comp program. And that's it for me. And if you have any questions, I'd be happy to answer them.
Great, thank you so much for your presentation. That gives a good perspective of what's going on with LA County as far as LA County government. So thank you. I appreciate you differentiating the public safety folks as well, because I know there are specific reasons why they're higher. But thank you. Really appreciate the perspective.
You're welcome. Thank you.
Great. Now, beginning our last panel, we're going to be discussing the perspective of the payer and the worker in the LA workers' comp market. We'll begin with Bernardo de la Torre, who's the legislative chair for the California Applicants Attorneys Association, to give their perspective.
First of all, I want to thank the committee for allowing me to speak, and thank everyone here present for being concerned about workers' compensation in California. I'd like to make a few comments on this, and what I presented to you was a chart. I want to thank the Department of Industrial Relations for releasing that in November. and an indication showing that the top chart, it's 2 on 1 page, shows the number of claims in California. And if you can see, there's the claims from 2002 to 2014 have been consistently going down. So that's a total number of claims. They also divide them into 3 sets. The green is the total claims, period. Someone gets hurt, Band-Aid, aspirin. The red would be a subset of that. That would be the ones where you have missed time, okay? And then the lower one, the white-colored one, would be the days away from work. Now, we have heard various times people have mentioned that 85% of the costs are due to these permanent disability claims. That's those white claims. Days away from work. They're going to come. Now, there might be one and the other ones here and there, but the vast majority should be in that group. Those are the claims that are producing 85% of the cost of workers' compensation. So, on one point, when we're giving IMR statistics, it's I would allege that they're including all the green and all the red. And that distorts the picture. Because the serious injuries are those there in that lower section. The other chart, also thank you to the Department of Industrial Relations, is race at the ethnic origin of that lower, the most serious injuries. And we see who are the people who are the most seriously injured. It's the Latinos. It's immigrant workers. That could be seen because in 2012, by the way, I didn't bring the other chart, but deaths on the job have been going down just the same way as all these have been going down, except for one subgroup, Latinos. Latinos suffered 38 deaths in 2012, 66 in 2013. See, and that brings me to the main point that I want to make in my presentation. Everyone is talking numbers, okay? The only number that I missed is the profit from insurance companies. For some reason, no one brought that up. But obviously, they would not still be in business if they were not making a nice little profit. So we must include them in the group of profiteering, because they're profiteering on the backs of human disaster. And the human disaster is deaths on the job, and all those people who nearly die on the job and create those severe injuries. And the statistics tell us they are Latinos, disproportionately so. And where are the Latinos at in California? In the Los Angeles basin, okay? No one here spoke, we have higher claim costs. Well, if you have more severe injuries, it's going to cost more. We should be doing something about preventing those. Also, they say, well, higher PD rates are a cost driver. That's higher permanent disability rates. Well, a cost driver of higher permanent disability rates is not the fact that you get an attorney, even though I am one and I do this as my job. It's the fact that you're hurt. And if you're more seriously hurt, you're going to have a higher permanent disability. Now, what's interesting is they commented somehow or other attorney involvement as though that may be a bad thing. Not for me as an attorney, but I guess for some it could be. But if you notice in the LA area, LA region, which is Los Angeles, Orange County, Santa Ana, and I believe Ventura, the Valley, the average, the number one reason I hear from my clients is, I'm going to get fired. That's why so they take 21 days because they're hoping it goes away. It doesn't go away. They finally tell their employer 21 days later, on the average, it's going to take another month to get treated in the LA area. What are you going to do if you finally tell your employer you're hurt? That's because you're really hurt. You need to see a doctor. If they stall you for another month, what are you going to do? You're going to go see a lawyer. And it's also interesting that for some reason, we have the mediocre claims adjusters in the LA area aggravating the whole problem. Instead of having the best adjusters where you would think they have the more serious injuries, we have the mediocre ones who exacerbate the situation. There were- Now, what's interesting is during the last 10 years or so, we also have a big boom in population in the LA Basin. There's approximately 1.8 million more Latinos in the LA Basin during that time. The growth has been seen Southeast LA County, Northern Orange County, and the Inland Empire. If we compare that with the statistics, again, from the Department of Industrial Relations that are saying 3 out of 4, or 75% of the days away from work are Latinos. The reasons I'm as a workers' compensation attorney, and I'm bringing into what's going on here is we have an increase, we have a negligence on the part of the system to take care of Latino workers. No one spoke about that. When their own statistics, the statistics that's presented to us are saying these people are dying more, are getting hurt more, and getting hurt more severely, and instead we're trying to say, well, look, I'm sure there's other factors. And yes, there has to be profiteering other than insurance companies, but no one makes more than insurance companies. So what are we to do? Either we must recognize the immigrant population, which is overwhelming Latino, to be very injury prone and to be very frail, or we should take some steps to remedy that situation. Thank you.
Thank you. Appreciate that perspective, and I think that that we get to actually maybe do a future hearing on maybe looking at the differences between the privately insured and maybe the self-insured and see how that varies and see what kind of profits we're talking about. But you're right, it's not, we didn't really look into that in this particular discussion, but appreciate that perspective, Mr. De La Torre. Next, I would like to bring up Mitch Seaman, legislative advocate for the California Labor Federation. Thank you, Mitch.
Thank you, Senator Mendoza and staff, and thank you very much for holding the hearing and drawing attention to these issues. My name is Mitch Seaman. I'm a lobbyist with the California Labor Federation, and also along with Bruce Wick, one of 4 public members on the governing committee of the Workers' Compensation Insurance Rating Bureau, where we have heard about this issue repeatedly over and over again for a long time. And it's something that is always brought up as sort of a problem, that things cost more in LA than they do everywhere else. And then when that's described, there's this sort of implicit assumption that something must be going wrong in LA, that because things cost more there, there's something going wrong there that needs to be addressed. And so we've learned a lot today about what could be behind that, and I think other speakers have touched on it, but I think it's important to emphasize that just because the system may cost less in other areas of the state, or the numbers show reduced frequency in other areas of the state, that doesn't necessarily mean that other areas of the state present a model to be emulated in LA. The same way that when we compare California to other states, and when we look at why other states typically have less expensive systems than ours, that doesn't necessarily mean that their systems are better than ours. There's all kinds of evidence out there that injured workers have an even tougher time in other states getting the benefits and treatment that they need than they do in California. And so we think it's really important to always make sure that that frame is always around this issue, that it doesn't necessarily follow from increased costs, that this is a problem, this needs to be fixed, there are lots of things going wrong. But the other side of that is that just because, let's say, workers are getting more treatment in LA, or there are more office visits per claim, that doesn't necessarily mean that the system is working better in LA. That what we need to do is take the kind of really close, data-driven look at the system that we have been, and especially the presentation from CWCI got into some of these questions that, that I had a long list of that she answered, and so the presentation's gonna be a lot shorter than I thought it was gonna be. And that's the sort of thing that we really need to do. We need to look at all of these different factors that could be underlying why things cost more in LA, make sure that we've got the list of questions that we need answered, that we've got a way of getting reliable data that we can use to answer those questions and then going from there. But it's also important to point out that there's a lot happening out there to workers that isn't reflected in the numbers. No one thinks that every workplace injury actually turns into a workers' comp claim. Many, if not most, injuries never turn into that. The applicant attorney's representative mentioned that there are all sorts of reasons why workers don't want to file a claim. Sometimes it's a risk of employer retaliation. Sometimes they don't think they're going to be retaliated against. It's more just kind of a thing that workers, they don't want to deal with the hassle, but they also don't want to, they want to look strong. They don't want to look weak in front of their coworkers. They want to just work through it, as he mentioned, hope it goes away, and that it's something that they can just deal with without having to jump into the system with unknown results. As much work as we've put into the California workers' compensation system, it remains an extremely complicated and adversarial and grueling system for workers, and probably always will, no matter what we can do. But at the same time, as long as that fact exists, you're going to see a lot of workers that don't report their injuries. And so, for example, what evidence do we have that injuries are getting reported at the same rate in LA as they are in other areas of the state? Do we know that workers, for whatever reason, are less likely to report their injury or report their injury accurately to the treating physician in other areas of the state as they are in LA? And so these are also on the list of questions that we really need to answer. We've touched on the issue of industrial mix and whether or not these numbers control for industrial mix. And through looking at all the different reports that are out there, some of them do, some of them don't, but some of them talk about this historical difference between LA and the rest of the state, some of which is due to industrial mix. So we would argue that there's probably still a lot more research to be done in figuring out whether or not some of this is related to the type of job, and not only the type of job, but what sort of other factors exist in that industry sector. Is there a greater risk of retaliation in the warehouse sector in LA than in other areas of the state? Things like that could also be driving part of this. We would also point out that the nature of work is changing in a lot of ways that aren't always good for workers. So as we've seen the rise of temporary employment in a lot of industries, it does definitely present some pretty scary numbers from our perspective. The research shows that workers who are employed by temporary agencies are far more likely to get injured, especially if they're in a more dangerous occupation, like warehouse or construction or manufacturing. And while the numbers don't make it look like it's a huge percentage of workers that are technically employed by temporary agencies, we don't have great data in that area either, where a lot of the employers in this space don't self-identify as temporary agency employers. And so there's a lot that we don't know about how that could be affecting some of these numbers that we're seeing. We would also urge a closer examination of the interaction between the Cal OSHA infrastructure and the workers' comp infrastructure. So, for example, questions of training. We know that a lack of training in language that the worker can understand is often the direct primary driver of a workplace injury. What do we know about whether or not training is taking place, adequate training, in a way that the worker can understand in LA compared to the rest of the state? Do we have any evidence out there that shows they're on an equal footing, or is this something that we haven't really looked into? And if not, it's something that we probably should, especially if the goal is to come up with some sort of policy recommendation to help deal with this disparity and analyze what it is that we should do. The issue of attorney involvement has also been brought up, and until today, I had always assumed that attorney involvement meant applicant attorneys when it was brought up as just one term, but knowing that we spend twice as much on employer defense side attorneys than is spent on applicant attorneys, we should also take a closer look at that. When is it that employer side defense attorneys get involved? Are we sure that this is producing better outcomes for workers? Are we sure that this is contributing to a system that overall gets workers back to work faster with the treatment that they need? If so, great. If not, then that's something that we should take a look at. And again, not to say that that's necessarily a problem, but what are the effects of greater employer side defense attorney involvement? Obviously, there's an increased cost, but we should make sure that it is something that is actually producing a better workers' comp system, or at least learn as much about it as we possibly can. We would also urge another look at back into the Cal OSHA infrastructure system, whether or not the resources are the same here in the LA area as they are in the rest of the state. Are inspections happening as much? Are employee reports of safety violations being followed up on to the degree that they are in the rest of the state? So in other words, are workers facing a more dangerous workplace environment here in LA than they are in the rest of the state? Hopefully not, but it's a possibility and something that we should definitely take a look at. And overall, we think this entire debate would really benefit from, to the greatest degree that we can, combining these Cal OSHA questions with these questions about the workers' comp system, because we really do see them as closely interrelated, and too often they get separated in all these debates. And we think workers would definitely benefit from bringing them closer together as much as possible. And finally, we would just argue that nowhere in all of these numbers do we see any kind of compelling evidence of worker fraud. That, again, from the perspective of a worker, this is a really intimidating system. And so when they get hurt and they go see their treating physician, they just they report their injury as accurately as they possibly can and hope for the best. And if, for example, let's say the research shows that there's an overuse of medical services here in the LA area, or treatments being prescribed that's more expensive than other equivalent treatment, it shouldn't fall to the worker to overrule their physician or to be aware of all this. And so as we explore whatever policy responses will best respond to whatever problems we find, we should keep in mind that the worker can't be, an injured worker especially, can't be expected to know the costs of all these different treatments and whether this physician is as adequate as that one, and all these different specifics that we need to fold into this debate. A lot of this can't fall to the worker, and that it needs to fall to other areas of the system to make sure that the system does work better, because from our perspective, that really needs to be the founding principle of this entire debate is what's the workers' compensation system that gets workers the adequate, timely treatment that they need so that ideally they can get back to work at the job of injury, and if not, another job that'll help them succeed. But that overall, the question of costs is important, but we think it's secondary to making sure that whatever we do, we preserve the benefits of the workers' comp system and that we do whatever we can to enhance its ability to get workers back to work in a timely fashion with adequate treatment and hopefully at their job of injury. Thank you.
Thank you, Mitch. Appreciate the presentation. Next, I would like to bring up Dr. Robert Wales, Vice President of the Board of California Medical Association. Thank you for being here.
Thank you to Senator Mendoza. I am Bob Wales, and I'm wearing a number of different hats today. I'm here from the CMA as an officer of the CMA. I'm also a practicing physician in the work comp system, and I'm also an employer. So I play, work comp premiums like everybody else. My specialty is actually pain medicine, and so I deal with a lot of different complex issues. The most common thing is spine injury. 70% of my work is spine injury. So as we know, low back pain is a common thing for our injured workers. And so I'll come back to some of that a little bit later. But my comments will be fairly brief today. But I do want to start by saying, as someone familiar with the workers' compensation system, I want to say thank you for inviting us to speak on behalf of providers and what we advocate for, and that is the best care for our patients. That's really what we're here to talk about within the workers' compensation system. Our first role and foremost is to provide optimum care and advocate for our patients. Now, we want to treat our workers in the most efficient manner in order to allow the injured worker to get back to work. I'm going to circle back to that a little bit later as well. It's important that we're here today discussing these issues about LA, but their interconnection throughout the systems are obvious. And we think that a system that's working better for the entire state obviously will reflect with improvements in LA as well. We want to make sure that the workers are receiving the necessary medical care in a timely manner throughout the entire state. This means looking at the entire system from beginning to end and figuring out what can be improved, what processes can be improved. For instance, empowering physicians that are delivering good care and good outcomes within the system and holding those physician outliers accountable for their actions through outreach, education, and better feedback on their performance can improve the overall system. We need to work closer and better by educating stakeholders on the recent changes with SB 863. This has been in effect now for a couple of years, and the fact is the addition of IMR and some of the other nuances of 863 are not well known for the entire physician community. And there's a ripple effect of that. So without as good of knowledge as we have, we should have as providers, we may not be providing the best documentation and so forth. So I think there's some real opportunity, and that's certainly true in the LA Basin area as well, to provide better education and outreach regarding the documentation responsibilities and how to appropriately ask for authorizations and how to do appropriate appeals when they are denied, which from my perspective is all too common. We also need to consider improvements in the IMR process. I have to say that physicians are not, providers in the work comp system are not in love with the IMR process, though we certainly understand and work with it. We much prefer having a physician actually examine the patient. That's much better than a third-party review of medical records. But what can be improved are such things as improving the review decision letters with an improved clinical case summary and discussion of the reviewer's decision rationale as much as possible. If you have a good discussion about the reviewer's rationale and why they're denying or accepting the treatment authorization request, that has a secondary benefit of educating physicians as well as claims administrators regarding what medical care is necessary and appropriate, so that in the future there may be less need for independent medical reviews on similar topics and similar experiences going forward. And I think that's important. We should also do our best to educate and empower the injured worker so they understand more about the process of their own health. And that's kind of a general medical comment, but I think it's really important in the workers' comp system so they understand the system. So better education with handouts and information, educating them on what they can expect, what's coming up, what the process is, so they can work within that process independently or with an attorney if necessary to get their needs met. We want to focus, we want to actually reward providers that do a good job, that have better outcomes, and try to educate those providers without as good outcomes, what processes, what ways we can improve their medical practices for the injured worker. Ensuring an outcome focus will also assist the carriers as to what providers they want to utilize. Now, one of the problems we have from the provider side is narrow networks, and the medical provider networks within the workers' comp systems are not transparent at all. Even when we ask for who we can refer physicians to, sometimes it's many days before they can get back and tell us who's in the panel, who's in their provider networks. So greater transparency on that would be helpful. And also having adequate provider networks, I think, is really critical. It's the same issue with non-injured, non-workers' compensation, but having too narrow networks means that the injured worker does not have access to the necessary specialties. To truly ensure accountability, there needs to be better transparency among different agencies as well. For example, the Department of Workers' Compensation, the Division of Workers' Compensation can work together with the Medical Board of California on some of the accountability issues and on educating workers' compensation directors and reviewers, especially since this is the practice of medicine. Most importantly, I think from our perspective and in terms of costs and efficiencies within the system is the utilization review process. And as a provider, this is where we interface with the workers' compensation system most frequently. More transparency in the processes occurring can help discover efficiencies and ways to cut costs as well. We need to make sure that cost containment measures are actually containing costs. As we discussed independent medical review, we should realize that that is not a go-to thing. That's an appeals process that should not have to be utilized frequently. That if we use the independent medical review process, it's because of a failure in the utilization review process. And there's not information tracked, and there's no transparency available within the UR system compared to the IMR. When it gets to the IMR, it's more public information. But for the UR, it's basically carrier-based, and there's practices there that are not ideal from the provider and patient point of view. The number of IMR requests is going to be directly related to the number of utilization review denials that are occurring. So the poor utilization review process will cause more IMRs, of course. And some things are simple in this regard. So for example, when I'm dealing with utilization reviews, a lot of times I'll get a denial and then I'll have a peer-to-peer conversation, and it'll be with an out-of-state physician who's not even in my specialty. And you cannot expect an occupational med doctor or a family practice doctor who doesn't deal with the intricacies and nuances of my specialty, and it can be any specialty, to understand what specific medicines I need and the characteristics of the procedures that I want to do and the pros and cons. The further frustration with utilization review is sometimes they'll rely solely on outcome studies when there's no evidence or outcome studies to rely upon. And so that's very difficult. An example would be, I have a patient who has chronic pain, of multiple problems and has chronic pain, who responds wonderfully to acupuncture. And when they do not get authorization for their acupuncture, which comes and goes intermittently throughout the year, they have to rely on narcotics. Now, when they use narcotics, that's not their choice. They don't like narcotics. It has multiple side effects. It also has all the different problems that our society is dealing with overuse of narcotics and diversion, et cetera. All those things are possible, yet that's the alternative that the workers' comp carrier is providing for this patient by not authorizing a non-invasive procedure such as acupuncture, which is effective for this patient. They have much better abilities to do their activities of daily living, and they function at a much higher level, which is really what we're looking for, higher functioning status. Yet there's no good process there's not a evidence-based study that can support this exact case. And so without evidence-based studies, which we'll never have enough of those will never cover every single situation, there has to be some judgment involved. And again, this is a case where the judgment goes against what logically would be the best treatment for the patient. Other examples are frequent. The most common thing that I see is low back pain, and that's a very common problem. And the importance, they've always shown this in multiple studies, that the quicker you can work on the low back pain, the quicker they'll get back to work, the much better long-term prognosis. They've always shown that. And so they need to get into physical therapy quickly. They need to be doing stretching and exercises and core strengthening. And yet, when the biggest problem I have is getting authorization for these treatments. And when there's a delay in the treatment, a couple things happen. Number one, you get an angry, frustrated worker, and they get angry at the system, they get angry at their employer indirectly, but mostly angry at the carrier. And then they get frustrated, and they don't do as well. So there's the frustration, and then they're not getting the care. And the longer you suffer from any type of injury, the more likely it is to be chronic. And so that's a real problem. So in closing, I would just like to say that there's no one reason in terms of why LA's problems are worse than any others. I enjoyed looking at all the data today, and it's very interesting. There are some very unique situations that appear to be relevant to LA. I would love to see more statistics based on per capita, not just regions, because I mean, obviously there's different populations in different regions, but per patient or per patient population. The best statistics would be the injuries per worker, because Northern California obviously is less populated, so it's by region it's going to have fewer people, but also they may have fewer workers per their population. So there's a lot of different ways to look at this data which would be useful for your deliberations. But I just want to say that LA is simply providing us a magnified view of the problems that are statewide. So I appreciate your focus on this and looking at this situation, and would offer the California Medical Association's cooperation in any way we can assist with that. And our goal as providers is to provide the best care and best outcome for the patient, because that's really what we're all here for, is the best care of the patient. Thank you very much.
Great, thank you so much for your information. Great presentation. It's good to have the medical perspective. We'll go ahead and bring up our last speaker, Bruce Wick, Director of Risk Management for the California Professional Association of Specialty Contractors.
Thank you, Senator Mendoza, and appreciate being here. This is a serious issue, and I'm glad we're taking a very thorough look at it today. CalPASC, our association is a nonprofit trade association. We have members statewide. This is a serious issue for my LA Basin members. They're paying more in workers' comp, as Mr. Priven showed, than their compadres across the state. And it's a competitive issue for them as well, that you can have a contractor in Bakersfield or San Diego bid for work in LA, and they have a 30% workers' comp advantage over the LA Basin employer. That's really unfair to the employer and their workers. When I talk to our members across the state and LA Basin, they all say, we do the same thing in the LA Basin. The best practices, great safety programs, proactive claims management. Why are our claims higher here than they are in the rest of the state? And when I talk with brokers, claims personnel across the state, especially in Northern Cal, they say, how can it be we have the same laws, rules, and regulations here in the LA Basin as we do across the state? Why is it so much harder to deal with claims? Why are they more expensive? So it's an important area to deal with. I'd like to talk about 4 possible component areas of this problem, and I'll try and offer a couple of solutions that I think might help us look at that. The first is the underground economy. My association leads the Construction Enforcement Coalition, which has been battling the underground economy for 6 years. And these are employers who cheat the system, cheat their employees, and my members don't want to compete with them. It's unfair. They get underbid, and they know they're not bidding fairly. So we've been working on this. We've been making headway. I believe this is significant because your underground employers do a lot of different things. Some of them buy no workers' comp at all. And that way, when their worker gets injured, they try and stonewall them on taking care of the claim. That's a real problem. The other part is they'll buy a workers' comp policy but underreport the payroll to get a lower premium. They turn in the claims, but they don't pay their appropriate premium, and that underreporting can skew the rates, the frequency rates and so forth that Mr. Priven talked about. The underground economy is throughout the state, but if it's worse here in the LA Basin, that would exacerbate the problem here. And I would suggest there's a group called the Labor Enforcement Task Force that was established by Christine Baker and the DIR 5 years ago. It's a multi-agency group, and they've done great work. They're learning all the time. They target the bad actors. They go after them hard because we want them put out of business. Or either come into compliance or go out of business. There's no middle ground for them. I think they could be very helpful in identifying, do we have a bigger problem here in the LA Basin, and what would be their strategies for trying to combat it. And I'll piggyback on my friend Mitch Siemens' comment. Cal OSHA and workers' comp together, what we find is the underground employer doesn't go part way. If they're going to mistreat their employees and cheat, it's workers' comp mistreatment. It's labor law mistreatment. It's Cal OSHA reg mistreatment. And so this combined group, the LATF, is able to bring the full court press, so to speak, on these employers to try and bring them into compliance. So I think that they would be a great resource to ally with in terms of understanding this and trying to strategize on combating the underground employer part of this. Mm-hmm. The second part is, you heard about profiteering. Insurance Commissioner Jones has really stepped up the push towards dealing with what's called provider fraud, the profiteering in the system. And I want to just make 2 comments about that. One is people can think that's providers, and again, you heard from CMA, there's a lot of great physicians that do a lot of great work and take care of our employees, but there's a few bad apples. Those that do defraud the system are not defrauding insurers, because insurers are just going to add that to the claims costs and pass it on to the employers. And it's employers who take the dollar risk. But the more important thing is it's our workers who get abused by the fraud. They get overtreated, they get undertreated, they get mistreated, and they're the pawns in that fraud scheme. So it is an important area for us to go to the profiteering because our employees do pay a serious price for that. Thirdly, we have heard attorney involvement litigation rates are higher in the LA Basin. When I talk with my members up north in Northern Cal, they're disappointed sometimes when they're taking care of an employee and the employee turns to an attorney. In the LA Basin, they're frustrated and angry. Now, I totally understand. We've got underground employers out there not doing a good job, mistreating their employees. Those workers need an advocate. They need an attorney to take care of them. I have seen claims adjusters mishandle a claim, and the employee needs an attorney to step in and take care of that. You can have legitimate disputes. Was it a work-related injury? What's the extent of the injury? Those kind of things. So, and workers do need attorneys involved, but it's such a higher amount here in the LA Basin. And my employers here see it just more often, and they get frustrated about it. And I'll give you two quick examples of where it doesn't make sense that the employee went to an attorney. One is one of our contractors, an employee had a fall. Another contractor caused the problem by not securing a wall. But the duties in California are you as the employer, regardless of whose fault it was, you have to take care of the worker, and this employer did. Their bilingual health and safety officer went to the hospital, met with the family, provided gas cards and food cards so the employee's family could stay with him. Surgery was done very promptly. They're talking with the employee, he's getting ready to go back to work, and on 4 months after the injury, everybody's happy. A government inspector comes in who's checking things out and says, I want to speak to the employee privately. The employee didn't want to do it. It was demanded. That was Friday afternoon. Monday afternoon, the employer gets a call from an attorney in downtown LA representing the employee 25 miles from their home and say, I'm taking over this case. I now represent the worker. Why? The worker has now given up 15% of the permanent disability award, and now they're at a distance with their employer, and unfortunately, our experience is in those types of cases, the employee never winds up coming back to work for that employer, and that's really sad, because that's the goal. You want to restore the employee to what they had before the injury. Another one, an employee in Victorville fell coming out of a truck. You know, those kind of things happen. Immediately sent to the clinic. Was getting, they checked him out, nothing broken or so forth. Come back in a week, take a week off. Come back in a week, we'll recheck, and, hopefully you'll be able to go back to work. 4 days after the injury, the employee in Victorville is suddenly signed up with an attorney in Santa Ana who tells him to go to a clinic in Riverside for treatment, 50 miles from his home. And when that same clinic has an office 5 miles from his home in Victorville. Why would somebody do that? It makes no sense. So while I understand there are times employees need attorneys, for some reason in the LA Basin, they are more drawn to doing that when it really hurts the employee. The fourth concept is, and I want to say this very respectfully, and it's already been said to a degree, we have a lot of people come here from all across the world, from many different cultures. And every culture is unique and worthy of respect. But when people come here from, across the Pacific or whatever, they come here either they were business owners and they want to own a business here, or they were workers and they want to work here. They're used to whatever the rules were where they came from. Our rules are better. I say that very respectfully of us. Employers have much more duties and obligations here, and employees have much more rights here. But a lot of times they don't know it. And a lot of times when I see these underground employers, some of them are just lousy human beings who will take advantage of employers and whatever, no matter how much you educate them. But I think some of the time I get the sense the employer is saying, well, this is how I did it back home. What's wrong with that? Why am I in trouble? Well, you're in trouble because your rules wherever you came from are not the rules here. You have duties here that are much higher, much stronger, and much more protective. So, and I think a similar thing for employees. 2 weeks ago, Assemblymember Hernandez had a hearing in downtown LA on the Hispanic why Hispanic injury rates are higher. And I really think we ought to kind of work together on those things, because I think there is correlation, and hopefully the two committees, in each house could kind of come together talking about those issues. They are serious and important. They talked about employees don't know their rights. And I think that's evidenced in the data, how long some employees take to report a claim to their employers. When my employers tell their employee, you have to report to me, and you have to do it right away because we need to get you treatment. Obviously, a lot of employers aren't giving their workers that kind of information. And there are some employers who then delay and try and stonewall the employee. So that's clearly happening. I think sometimes employees think, because they don't have to pay money up front, this won't cost them anything. Well, it does cost them, and sometimes there's value in having representation, but there is something there. So I would suggest one of the things we really could do, and this could be really put into one package, is a public education program. Social media allows us in different ways to give messages to a lot of people pretty efficiently. We need employers, especially employers from other countries, to understand the rules here in California and their duties to workers. I believe a lot of them, would comply if they knew this is reality, this is what we expect, and not only what we expect, we demand it. You have to do what we say. And workers, too, to know their rights, that they can't be retaliated against, they can't be fired, and this thing, so they get the proper treatment, they get more comfortable turning things in, and then telling workers, if you have every right to hire an attorney, this is what it means when you do. This is why you might consider doing it, but you're going to give up part of your PD award. You're going to be at a distance. You won't be able to talk to the claims adjuster. The claims adjuster won't be able to talk to you directly. So I think that could go a long ways. That's a lot of what was talked about in Assemblymember Hernandez's hearing, and I really think we could go a long ways just towards educating the populace as a whole. So, thank you very much.
Thank you so much for your information. I think the panelists today, the three panels, really had a good overall perspective. They set the groundwork on some of the stats. The other panels talked about what might be contributing to the higher costs here in Valley County. I think there's a lot of moving targets, a lot of reasons, a lot of things that actually can contribute to a higher cost here in LA County, but there's still a lot of unanswered questions. I do appreciate the recommendations that were made, some of the things that we could continue to look into, not only from the medical perspective. We just heard from the employer perspective and also the workers' perspective. I do think there's still a lot of work to be done in actually having our employees or our workers know their rights and know what's available to them as a starting point to begin to maybe look at some of these costs here in LA County. But there's still a lot more to be done. This hearing was just an opportunity for us to come together and begin to discuss the factors that could contribute to higher costs here in LA County as we look at the state as a whole. Will we continue to doing more hearings on workers' compensation in the coming year? We've done a few hearings this year, and for me as the chair of the Labor Committee, it's an opportunity for us to not only educate the public as we are broadcasting live here via the web, but also an opportunity for all of us to kind of look at those circumstances that we could look into future legislation or future opportunities to kind of help in the workers' comp cost. For many years since I've been a representative here in this community, I hear from employers about the high workers' comp issue, and it's something that I think we've always trying to put our hands around and try to do something about it, and that's what we want to continue to do. I appreciate the feedback. I know that you just mentioned about working with the other committees as far as assembly side, and yes, we plan to do that as well. And we have a few committee members here, members of the staff this particular committee. Gideon Baum here to my right, he He's actually worked on the workers' comp issue for many, many, many years, and is very, very informed individual about what's going on, not only currently or in the past. And he has cards available for everyone out here and anybody who's listening to us or watching us on the internet. His information is available on the net and also in the state capitol. There are several questions that you might have out there, and as it relates to this issue, what's coming up in legislation, I urge you to contact him and get the most recent perspective of what's going on. But I do want to thank everybody for being here, and I want to thank the city of Downey for hosting us and allowing us to be here to have this very important meeting. I do want to thank all the participants, the panelists that provided a lot of good information, a lot of latest and greatest information. I appreciate that. And I think for all of us in the audience that are walking away with this information, it's something for you to go back and really dive into it, not only yourself, but your respective companies or organizations. I think you'll find this information to be very informative. But this is there's not a one single solution to the problem. It's multifaceted, and we have to kind of take that global approach to we could continue to help drive down the cost of workers' comp, and at the same time not neglect the needs of the workers who are actually the ultimate injured individuals who want to provide for their families. So with that, I just want to take a moment to thank Gideon Baum for putting this meeting together, and also our newest consultant to the Labor Committee, Brendan Seto, right next to me. I want to thank the Senate staffers that came and provided all the IT work to provide the internet for us, and my staff that's in the back also that help organize this event. So again, thank you all for being here. Enjoy the rest of the day, and please, if you have any questions or any concerns or anything, please make sure you take Gideon's card, and we'll make sure that we address them accordingly. Thank you so much. Have a nice day. Thank you. We will allow for some public comment please step forward in case somebody wants to ask or just make any comment. That'd be great. Thank you. Sorry about that.
Thank you for hearing us. I've been in practice as a doctor for a little over 20 years, treating all kinds of injuries in patients. And basically, I wanted to just make a comment and perhaps a solution to what we have is called liens in the work comp system. The reason why a doctor files a lien or a provider files a lien is because they haven't been paid properly. When a doctor sends a bill to an insurance carrier and asks for a payment and their insurance carrier refuses to pay that amount, many times the provider or doctor will say, okay, you know what, I'll accept 50% of that as full and final if you promise to pay me. If the insurance carrier says, no, we're not going to pay you, in my opinion, this should be brought in front of a judge. If a provider is asking for a reasonable fee, the judge says, you know what, that's reasonable, it should be paid. In my opinion, the provider should be paid triple what they're asking for. If the judge says, no, that's too much you're asking for, then the provider should be paid nothing. They walk away. That way, both sides have something to gain and something to lose. It would decrease the amount of litigation that goes to court because both sides have something to lose if they go to court.
Right.
This would definitely decrease the amount of liens that would be found in the work comp system.
So
Okay?
you leave it up to a judge who would actually make the decision
If they agree with the
something's
provider,
too obscene or something is more reasonable.
That's
and
correct.
something-
And both sides have, you either get paid what you're accepting times 3, or you get paid nothing. That way, both sides can have a reasonable agreement to be made. And a wise man once said, when both parties are upset or happy about an agreement, it's a fair compromise.
Thank you
Okay?
for the
I think
thank
that's
you.
very, very fair. And the other issue I wanted to just to state briefly is, when a person is injured on the job and their claim gets denied, they cannot get treated under work comp. They can get treated, but it's not going to be authorized by the insurance carrier. They didn't maybe try to use their private insurance. And there's a information sheet that's filled out. If you say if it's due to work-related, most insurance doctors will say, I'm sorry, I can't see you. It's work-related, and you have to go to a work comp injury. Tell me, maybe Ms. Overpeck can answer this. What should that person do when they can't get treated through the work comp system? They have insurance that they can't use. What should they do? They go to a doctor that works on a lien. And what happens to those doctors? They get penalized because now they have to pay $150 to see that patient to file a lien. And they're doing a community service by seeing someone that no one else would see. And they're doing it at a risk of not even getting paid. Yet, those doctors that do that are penalized. Why is that? Maybe someone has an answer, but I think that's a valid point and something to definitely think about. The doctors are being penalized for seeing patients that are injured, people that are injured on the job that cannot be treated anywhere else. And yet doctors are penalized, or other providers are penalized for this. And in my opinion, that's hypocrisy in this whole system.
Thank you. I
Okay,
appreciate
thank you,
bringing
thank
that
you.
up forward. Thank you. Appreciate that. Thank you.
Good morning,
Brett, how you
Senator
doing?
Mendoza. Mr. Baum, good to see you again. Brett Graham on behalf of Latino Comp. I'm an applicant attorney in Montebello in this district. There was a recent New York Times article, November 27, 2015, that talked about the surge in immigrant workplace deaths in New York City construction. Obviously, the ethnic blend of immigrants in New York City is a little bit different than it is here in Southern California, but the same thing is happening nationwide and in New York City, and I'll be happy to send a copy of that to staff. The idea is that the biggest cost driver in these workers' comp cases is serious, significant injuries and deaths, and we've seen a dramatic increase of those in immigrants recently. And I think that if we could do something in terms of education of the workers and the employers, that would cause dramatic cost savings, especially here in Southern California. One thing I wanted to respond to was the statement that liens take away resources from injured workers. That's not exactly correct. A lien means that an injured worker has gotten medical treatment, and there's a disagreement between the provider and the payer. There was a legislative decision to change the way that balance is done. Now, the injured worker needs to wait to get the medical treatment, and that's why there's been, per the studies, a 3 times increase in the number of expedited hearings in Southern California since 2012 when SB 899 SB 863 was passed. So now the injured worker needs to wait to get the treatment either through a court order or through UR or a IMR appeal, as opposed to the prior system where they would get treatment on a lien. So it's a balancing of the judicial resources, that hearings are taking place now on the front end rather than at the back end. And I can just tell you, my clients would rather get the treatment first and wait on their settlement than have a quicker court date on their settlement and wait for the treatment. The last thing I noticed from the information on the UR appeals and IMR overturning the UR denials done by Ms. David was that California licensed IMR doctors are approving treatment at a 50% higher rate than non-California licensed IMR reviewers. And that, I think, is significant. That was one of the issues that came up during the discussions on the legislation is, should the IMR reviewers be mandated to be California licensed physicians? And in my view, I think they should. They're more in touch with what goes on here in California, the types of practices that are done here in California. And I think that the statistics now show that. The statistics now show that if you, by luck, draw a California licensed IMR reviewer on your case, you have a 50% higher chance of getting that treatment approved that was denied by UR in the first instance. One thing that still remains a mystery to me, and I have never heard an explanation for it, is why the identity of the IMR reviewers remains secret. If the model was the Knox-Keene Act, the IMR reviewers under Knox-Keene are not confidential. They can be called to testify in court. Their identities can be revealed by a court order. And I'm not sure what the justification is to have the ultimate decider for an injured worker on the most important thing that they have, which is their medical treatment, to be a secret doctor that may be from out of state. thank you again for holding this hearing and for
Great.
hearing from all of us.
Thank you, good points. Thank you for bringing that forward.
Good morning, Senator Mendoza. Lance Garrett with the Garrett Law Group. We represent injured workers here in the Southern California area. And again, thank you and your staffing committee for holding these hearings, as you quoted earlier, to examine the challenges faced by the injured workers in obtaining the benefits and getting them back to work. I appreciate the efforts on behalf of the administration, Ms. Overpeck, and the variety of data that's been presented today. Much of it seems to be focused toward breaking down claims frequency between areas of the state, as opposed to your voiced mission of looking at the challenges faced by the injured worker and working on ways to see if they are locally based challenges. Some of Ms. Overpeck's initial comments in regards to the effect of SB 863 and the benefits that the injured workers have derived from it are appreciated. Yes, there has been an increase in permanent disability rates, and those are to be appreciated in the years to come. But we as practitioners, speaking personally for our office, it would be a single-digit percentage of cases where clients come to us and say, I need to be represented because I need my permanent disability. One of the most valuable assets in the workers' compensation system and the most valuable benefit, as is derived by much of the data we saw today, is medical treatment. Medical treatment is the access to the temporary disability and to the permanent disability award. Without medical evaluation and treatment access, there will be no temporary disability and there will be less permanent disability. And many of the changes that came as a result of 863, contrary to the administrative director's contention that it has improved medical care, our personal on-the-street experience as it has moved us backwards, excuse me, away from that ability to derive the benefit of medical treatment and evaluation in the system. The utilization of the medical provider networks, which has been so successful from my limited estimation in Northern California, faces challenges in the Southern California area premised upon the differences in the medical community as to the acceptance of disputed claims of injury. In Northern California, based on my historical read, you don't have a claim of injury. You are told you may want to go see the public clinic or access your Medi-Cal resources potentially to address your symptoms, but the community up north is very conservative in regards to access to medical evaluation before you even receive treatment. And then practitioners in the north are far more conservative about the cases that they accept. That alone may be one of the instances to take a look at in regards to claims frequency difference in areas of the state versus the San Joaquin Valley, Los Angeles County, and the other limited, narrow cast areas that the administrative director pointed out earlier. Because when an injured worker or an allegedly injured worker has representation, they have the opportunity to pursue a disputed claim of injury. In other areas of the state that are more conservative in their medical community, as well as their legal representation, if the insurance company doesn't say it's admitted, you don't have a claim of injury. You just have a hurt. And they leave you to the public resources through Medi-Cal for those injured workers and limited economic demographics have available to them to address their physical injuries, much less their work injury and their ability to return to their pre-injury income. Ms. Overpeck's observations in regards to the effectiveness of the IMR had some dichotomies within it which may take closer examination. She spoke to the time frame in which IMRs are to be completed, spoke of a limited number of those examinations and decisions that are being reached in a 10 or 12-day period, but yet overall she noted that it was taking 45 days to complete an IMR decision. There is regulatory authority for those IMR decisions and the IMR review organization of Maximus to be penalized, or the carriers to be penalized for not providing the necessary medical reporting to reach that determination in a timely fashion. I have no evidence at the present that any insurance carrier nor Maximus has been penalized under the authority that the administrator has been given a disparaging reference, as if they are not part of the system. They are the representation of the medical benefit provided to the injured worker, to echo Bart's comments earlier. So therefore, when the perspective was expressed that it takes away from the resources for the injured worker, that is part of the injured worker's benefit. It is a resource that the administrative adjudication process needs to focus on, as opposed to letting the case in chief resolve and then putting the medical provider's resolution of their reimbursements 2 years, 24, 36 months down the road. And I believe the efforts of the administration to utilize the lesser busy district offices is working toward that goal. And hopefully the pilot program in regards to the video conferencing that Ms. Overpeck spoke of will be more successful in alleviating those backlogs that they assert to exist. Hopefully you'll be able to move from the Anaheim office to the Los Angeles district office, which based on the current procedures appears to be the area where they feel the greater backlog is, because those cases are now sent to the Oxnard district office, inconveniencing injured workers, their representatives, and witnesses in those matters to travel to Oxnard to seek that reimbursement. Additionally, there was a reference in Ms. David's comments for the CWCI talking about the estimated total care modified or denied in workers' compensation cases. It was on her slide number 16. In that slide, it showed non-RFA approvals of 84.7%. A deeper drilling down into those numbers that they have available may bring to light that the majority of those requests are requests being made by medical provider network doctors who are under a statutory concern on a daily basis of being removed from the treatment networks by overprescribing or overtreating. So in a circumstance where a medical provider network doctor seeks approval, if you're only asking for what the insurance company wishes to approve, they have the right to approve it without a request for authorization. Other providers and practitioners in the disputed case model, which may be more prevalent in the Los Angeles area because of cultural density and diversity, as well as labor and manufacturing centers that may be more dense than in other areas of the state, those practitioners all are required to file the treatment request on the request for authorization. So how would it be that the non-RFA requests are approved at an 85% ratio, or 85% of the approvals, but yet only 11% of the approvals are to those that are requested on the request for authorization form? That may provide greater insights into the control that the carriers exert through their economic power in their medical provider networks. Because these, in our experience on a daily basis, are the issues that do present the barriers to the injured worker receiving the benefits necessary to return back to their pre-injury condition. The gentleman earlier from the from the California Professional Association of Specialty Contractors used a variety of examples to point out the concern for attorney involvement, and that the injured worker would then lose a percentage of their benefit because of the involvement of the attorney. There are other studies that also point out that that involvement of professional representation increases the benefits received by the injured worker by somewhere in the neighborhood of 19, 21%. So if you're concerned about an attorney fee, your overall recovery, much less your medical treatment evaluation you receive, is traditionally much higher in a represented case than in an unrepresented case. And lastly, the concern for what the barriers may be that exist locally, I think a common theme through many of the presentations today has been that education for the injured worker, especially as Mr. Delatorre spoke, those who have cultural barriers as to their abilities to communicate effectively with the administration and the wonderful information vehicles that they provide may go far to help all of us help return the injured workers to their pre-injury condition as the best the system allows. Thank you for your time.
Thank you so much. Appreciate that.
Certainly.
Hello,
Hi.
my name is Josephine Campos, and I am an injured worker. I was working as a temporary staffing company, and I was injured. I hurt my back. This happened on a Thursday. I reported it to the immediate supervisor. Following day, I reported it to the staffing agency, and I was told, well, your back is probably sore, you know, maybe wait for the weekend. Monday came, couldn't work, couldn't even put my underclothes on. That's how bad my injury was. I finally had to tell them on Tuesday, I need to see a doctor. You need to send me to a doctor. They finally sent me to one of their doctors, and the doctor took an x-ray, and he said, you're fine. You know, you have a little, he used his lips. He says, you have a little, you know, something on your back, but you're okay. I said, okay, but I can't put my underclothes on, I can't bend, I can't stoop. He says, no restrictions, you can go back to work. So I went to the agency and I said, I cannot work like this. Even though the doctor is telling me I cannot. So at the time, she says, okay, well, go home and rest a couple more days. So I had them transfer me to another doctor. The other doctor said, yes, you do require therapy. So I would go to therapy. I would miss 4 hours a day, 3 times a week of pay so that I can go do my therapy. After the therapy, I was about 80%, was okay. So when I went into the agency, I told them, okay, well, they said I can work now, that I'm okay. That day, they laid me off. So I was no longer working. So I was home. I still felt my back was bad. I was still doing my exercises, my therapy at home. And then this happened in September of 2013. In May of 2014, I was cleaning my bathtub, and there again, my back. So I had to go through this appeals process to see a doctor again, and to see, to get a doctor. I had to write Sacramento. I had to go through a lot of red tape just to see a doctor. When I finally saw a doctor, I had to go to a QME, a qualified medical evaluator, and she requested an MRI, and I did have a herniated disc. The MRI showed I had a herniated disc. So at that time, she did, the QME stated that I needed to go back to the doctor for possibly shots, medication, and so forth. So I went through the whole process of going back to the doctor, but I had to fight for every single thing. Even going through the QME, she told me, you were disabled between this period and this period, and I still got not a penny from workers' comp. I did not, get any compensation whatsoever. The only thing I wanted was to be healed, to be able to work. Anyways, I am now still dealing with my injury. I'm no longer seeing doctors, every 3 weeks, every 4 weeks. I did the acupuncture, did not help. I did the therapy. It helped temporarily. What I found through this process is there's no agency to help you throughout the process of where you need to go, what you need to do. If they tell you no, still, request the MRI. The doctors within the workers' comp, a lot of them initially, they just want to put a Band-Aid and send you on your way. When what you really need is you need to get that MRI so they could see that you truly are injured. And then facing the employers, that stigma that you have of that you're an injured worker, they make you feel like they discriminate against you. like you're pretending. No, I'm not pretending, I'm not lying. This is what's really happening to me. So it's very frustrating. We do need resources to help the injured worker and to educate the employer to not discriminate against that injured worker. That's all I have to say. Thank you.
Thank you so much for sharing your story. Appreciate that. Thank you.
Thank you, Senator Mendoza and the staff to hold this meeting. I'm a small business owner, legal service here based in Santa Fe Springs, and I just want to talk on a couple things. I know the lien issue has been a big issue, and I wanted to point out in respect to that. CSIMS provided a portal to download the number of unactivated liens with a DWC, and in her own words, she didn't know what that status of the liens were. Of my particular liens as a legal photocopy service, only 9.4% are open versus what they're claiming are sitting in their books. So they don't know what's going on. Of that 9.4%, 55% of those are from uninsured employers. That, for me, is normally serving a special notice of lawsuit, giving that employer notice. My bill average is about $85 for that service. Not unreasonable, with a fee schedule being at $180 to $75. With that, there's no provision in the fee schedule to address UEF issues, to address personal appearances, to appear at a court with fees for paying witness fees of $35 or even a state employee. Do you know how much a state employee witness fees are? They're $275. If I have to I'm asked to subpoena a sheriff or a police officer, state employee, it's $275 witness fee alone. The fee schedule doesn't even account for that at all. As far as the fee schedule goes, there's been two real frustrating things for me is sales tax. I've been dealing with the BOE for quite some time. Sales tax is not being paid, even though Regulation 9983 briefly touches on it. It says the reasonable maximum fee not including sales tax. The problem is a lot of these bill review companies are out-of-state companies. And what they're telling me, I've personally got on the phone, I've spoke with numerous bill review people, and they're saying, well, it's not in the code. There's not a code for sales tax. That's one issue. The other thing is shipping and handling. I have a set of records going to a defense attorney, 2,700 pages asked to be in paper, printed. I only charge 9 cents. I charged 9 cents a page even prior to the fee schedule. So my fees were actually more reasonable way back then. 2,700 pages is a pretty big stack of records. They want it in paper. They don't want it on disk. With that, there's no provisions for shipping and handling. Well, when I go buy something on eBay or whatever, that shipping and handling isn't included until I make that final purchase and they figure out where am I delivering that product to? What is that product going to take to deliver? So those are a couple things that are still unclear. As far as the records and evidence, I'm in a unique situation because I provide evidence actually on both sides. I do applicant work, I do defense work, I do self-insured work. How information, and a lot of information was presented here today, how information is looked at, that really is based on what your objective is. An applicant attorney is looking to prove and verify the injuries of an injured worker. A defense or employer is looking to deny or limit their liability in that claim. I'm also an employer and have had injured workers too, and been through the system where I've worked with my employee and that employee was denied treatment, never got an attorney, went through the process looking to get, he didn't report to me right away, he reported it 2 weeks after the fact that he was injured. That injury, I said right away, I went through the process, I know the system, I went through the process, they got a doctor, they did an MRI, but he saw the doctor for 10 months before they even authorized an MRI. Finally, he got surgery on that. After that MRI, he was still having problems after the surgery. The doctor, the NPN doctor on our panel, asked for him for another MRI. The carrier denied it. What do you think my employee did? Went to go see an attorney. You know, these are the things that have happened. lot of great information presented here today. We still need help, and I think just like Bruce talked about, is clarity of information. We need to be informed, not only at the working level, but also at the administration level, at the bill review level, at all levels. Thank you for your time.
Thank you. Thank you. Just to take a notice of time, we're probably to leave the chamber in a little bit. They got other things planned for this afternoon here for the chamber. Thank you.
Hi,
Marty.
Senator Mendoza and staff. I'm a government employee, and you know, I take pride in where I work and try to provide that old service, customer service, which we're losing in today's society. And what I'm finding out is that when you're trying to do good by your customers or by your coworkers, nowadays you're being punished. So what I've experienced is with my workers' comp case, what they're doing now, management, is they're using workers' comp to try to get rid of employees as well. Like, I've been off since August the 1st, and I'm begging to go back to work. I have had a workers' comp open since 2013, and I've worked through it, but now because it was an open case since 2013, they left room for retaliation against me. So with the retaliation against me now, they went to the doctor and HR utilization department. They came up with the method without even including me that I needed to be permanently disabled. And I go back to the doctor and I say, I'm not permanently disabled, I want to go back to work. And so that's what I'm finding out. I have a coworker that worked for the federal government, and instead of her being allowed to go back to work, they just want to put us on permanent disability. So if you guys are saying about the permanent disability prices are increasing, well, it's a lot of us that do not want to be on permanent disability, but they're using the workers' comp system to push us out as a retirement plan, and all I want to do is to go back to work. Thank you.
Thank you so much. I appreciate you sharing your story. Thank you.
Senator Mendoza, Gideon, Mr. Baum, thank you so much for having this this hearing. I think it's needed in probably all the districts in California. But, you know, I represent Voters Injured at Work, and we represent the injured worker. We don't do studies. I think they were very, very informative. I think what we tend to lose sometimes when we collect all this data is how it's impacting the injured worker. A lot of times before things are implemented, I think we should actually be seeing through them a little bit more clearly. And looking at the just some of the data that was collected, we're seeing that Southern California, you know, is rated real high in the workers' comp. I think it needs to be done is a data of how the injured worker is going to, in California, what the demographics are of injured workers in California. Because we all know that the Latino community based in Southern California is a lot higher than many other parts of the state. I think we should work more closely. The administration should work a little bit more closely with Cal OSHA to come up with some of that data. I think Cal OSHA could get a better reflection of what people are being affected, which ones are getting hurt more severely. Those are just, you know, some of the recommendations that we're making. But as hard as we're trying to make this system work, there's still a lot of injured workers that are suffering every day. Just some of the people that spoke just before me, hear some of the issues that they're having. To them, this data means nothing. You know, it's how we're working through that system and how it's making it easier for them to work through that system. It's still difficult for them to work through it. The system seems as if though, you know, there's language barriers that we're having difficulty working through. You know, most of the problems that we're hearing from injured workers is, you know, what do I do? You know, what's my next step? You know, what is my case is now going to a utilization review. What is this? You know, they're confused in the system. A lot of times that's the only thing that they have to do is to have an attorney, you know, to be able to get an attorney that's going to help them maneuver through that system, that they back off. You know, you could spend hours on the phone trying to speak to somebody to try to help you resolve one of your problems that you're having or your issues that you're having, and you run into one stone wall after another stone wall after another stone wall. So the system is very, very complex, and we can't just, I think, initiate things without looking at the perspective of the injured worker and the problem that they're having maneuvering through the system. I think it'll be more beneficial to get them a little bit more involved with some of this that's going on, that, you know, stakeholder meetings. That brings me to another topic. Very, very concerned with the formulary that we were. We were part of that stakeholders meeting. One thing that I'm very, very concerned with is people on opioids. They're removing them off of opioids. It's a blanketed system now. So it doesn't matter if you were injured and your case has been settled for 10 years, you still have to comply with the new formulary, and that's elimination of opioids. There's a 2-year winging them off of the opioids that they have a right to implement. But we don't know the data if after a person's been taking opioids for so many years, is he going to be able to get off those opioids? You know, are we going to create another underground black market of druggies that are out there looking for opioids in the black market? You know, what is it that we don't have that data? I've tried to get that data to see where if there's any data to show if a person that's been on opioids for a number of years, if they're able to wing themselves off of it. What the success rate is of that. Will they go back? Will they choose other drugs? You know, will they be going on heroin? These are all things that I brought them to the attention of that stakeholders meeting. We just never did get that data. And I can't find that data anywhere to be able to show that. But again, thank you so much for that. And the injured worker does need to have a voice. The injured worker is the one that's getting impacted by all these changes that we make in workers' comp. So I'd like to thank you for holding this hearing, and hopefully you'll hold some more hearings so we could get more injured workers' stories here.
Great.
Thank you
Jesse.
very much.
Appreciate you coming out. Thank you.
Good morning, Senator Mendoza. I want to thank you and the panels that you have elected to be here and given us all an opportunity to come and speak to you. As a certified medical interpreter, my name is Guadalupe Manriquez. I've been in this industry for over 25 years. I've had a great deal of thousands of injured workers that I have assisted throughout many years. I've done it for one purpose, because of my heart to help others. The system was created for caring. How can we go around caring for an injured worker? First of all, we would not have access to that opportunity if they did not have their attorneys, because many injured workers don't even get a chance to get the medical treatment that they should be getting. Even though the system says this or says that, it all is buried underneath all those books and all those pages. And that's why the attorney comes in. I am a neutral person. I'm just a voice. None of these people would ever get a chance to go to court and have a chance to express themselves without an interpreter. I can only share with you so much injustice from the court system, from the medical field. When do we stop? They can continue creating new laws that continue being amended post SB 863. We've communicated with Ms. Overpeck about all the issues that were going to be affecting interpreters. Did it help us? Not at all. We are asked as a voice. That's all who we are. We're only a communication. We do not supply any type of goods, but yet we have to file all these liens. Liens is a big portion of all this mess. Because we're forced, we can file a lien on one single data service. Do you think it's fair? If we charge $170 and we have to pay $150, of course insurance companies are gaining with lots of profits. There's a lot of free work that we are being forced to give up. We cannot file, we cannot collect. Insurance companies, you call them, they won't answer you. You call attorneys, they don't care. Because if you didn't file a lien, well then we don't have any reason to communicate with you. Where is the system going? Where is the need for public services? Responsibility. We all are responsible to whom? It's the injured worker. And yet they're not getting what they need. If their treatment was authorized because of one reason or another, it's only for a consultation. They're not given authorization for those MRIs that they talk about. I've been there, I sat there. So then you get another doctor that examines the patient. The doctor tells the patient word by word, I'm gonna allow you to get this and this and that. It doesn't happen. When the reports come in, all contrary to what the doctor said. Yes, the interpreter is a very important person in this whole picture, but it doesn't matter because we're not being considered in the whole aspect. I only plea that the system takes in consideration why they do need their attorneys, why they do need the interpreters, but why are we having to pay so harshly for what we do? We file liens. Los Angeles went ahead and threw all these liens away. Thousands of liens. Why? Because they were understaffed. They could not set up hearings just to be able to have anybody adjudicate all their outstanding liens. So now what do we have to pay? An activation fee. Who's got the time? Who's got the money when we're supposed to be out there helping the injured worker? Thank you for your time.
Thank you for all your comments, and we're gonna go ahead.
One last one?
We're like 10 minutes over, but if you could make it brief?
1 minute, okay?
Please.
I wanted to thank Senator Mendoza and the committee for having this hearing. My name is Rene Garcia, and I am here representing IGA. IGA is the Interpreters Guild of America. Okay. We are independent interpreters. We're not agencies. We're just interpreters working in the trenches. IGA is associated with the Communication Workers of America. Yes. It's a union association which I think provides some bona fides for what we are trying to do, which is give a voice to the independent contractor, to the independent interpreter. And I also want to call out Director Desi Overpeck, and we met with her, and I think that the DIR is doing a commendable job in trying to let all the stakeholders sort of have a say and pretty much assess carefully the fee schedule that they are taking under study right now. And I just wanted to say thank you for that, because it's really critical that to solve one problem, you don't create an even bigger problem. I think that, you know, as you can see here, and you've heard from the lady that spoke before me, the lien system is very frustrating and it's kind of broken. The fix is not an MPN system, though. The fix is not sending all of the interpreting services, which is really what we're most interested in, out of state to single payer agencies that aren't in-state providers. That's not the answer. And I think from the independent interpreter's point of view, the fee schedule is a great opportunity to ensure that the individual interpreter has appropriate compensation for the important work that they do. We don't want to see judges, insurance administrators, or hearing officials be tasked with provisionally certifying interpreters. The state does that. We, the interpreters, pay for our certification, pay for our continuing education, and there's no need in California for a system that basically doesn't have a way to enforce it. The draft of the fee schedule right now has provision for 3 interpreters being called, and if you can't get 3 certified interpreters, then you provisionally certify someone else. And I think even the DIR, I think they're hearing us when we say that this is untenable, this is not really the answer. And I think they're also hearing us when we say that the individual interpreter and what their compensation is really where the fee schedule should start from. And there's so many in cost containment, right? And the cost containment that has been implemented so far has created layers of middlemen and administrators, language service providers, agencies, and it's the independent interpreter ultimately who gets certified and who does the work. So thank you very much for your time.
Thank you again, everybody, for being here. I appreciate the comments. We're a little bit over our limit.
Okay.
If you want to state your name, your organization, and maybe
2 minutes.
If you really want to, I don't know if, yes, we have.
I'll send you an email.
Thank you, Moises, for being here. I appreciate that.
Okay.
Thank you. Thank you all for being here. I really appreciate your coming out, and all the speakers did a great job. Thank you so much for being here. Have a nice day.